Voilà. Jonathan, you hear us? Alors là, je peux. J'ai été coupé. Non, c'est en bas. Qui commence? Alors, hop. Normalement, voilà. Bonsoir à tous. Bienvenue dans cette salle internationale du tribunal de commerce de Paris. Une salle dont nous sommes très fiers, qui est la salle de la Chambre internationale, dans laquelle se plaident et se tiennent des audiences en anglais. Et donc, elle nous paraît parfaitement bienvenue pour tenir cette conférence ce soir à l'initiative de l'art, que je remercie d'avoir organisé cela, et compte tenu de la qualité des invités dont on vous dira un mot dans un instant. Donc, bienvenue au tribunal de commerce de Paris. On a plein de choses à se dire, donc on va passer très vite dans la matière, mais je vous cède la parole.
Merci. Pardon, bonsoir. Bonsoir à tous. Merci beaucoup de votre présence. Merci, Président Sayer, de nous accueillir. Je voudrais remercier aussi vos équipes, Armel Capellini qui a beaucoup œuvré pour l'organisation de cette conférence. On est particulièrement content de faire suite au colloque international qui a eu lieu le 5 décembre dernier dans le grand amphi de l'école de médecine, dans lequel on a commencé à travailler sur les différentes approches européennes de la mise en pratique de la directive européenne, justement. À ce moment-là, on avait évoqué les échanges avec le professeur Schwartz et les retours d'expérience des États-Unis qui sont revenus à l'occasion de plusieurs tables rondes. Donc, thank you, Professor, for joining again, since we've already had the pleasure to welcome you at the roundtable for ARE. Thank you, Professor Seymour, as well. You'll be introduced by Douglas. Et voilà, je vais laisser les spécialistes parler et Douglas les présenter. Merci beaucoup.
Parfait. Merci, Xavier. Monsieur le Président du tribunal. Mesdames, Messieurs, chers amis, et Jonathan, vous nous entendez. De la part de l'ARE, je souhaite d'abord remercier professeur Gwenel Nogachowski et professeur Nicolas Berland. Je vois que Nicolas est avec nous et Gwenel vient d'arriver just in time. Et l'Université Paris-Dauphine d'avoir accepté de s'associer à cet événement. Nous avons un partenariat profond à tous les niveaux et on le tient vraiment à cœur. J'ai l'honneur de vous présenter un ami de longue date avec qui j'ai eu le privilège d'enseigner à plusieurs reprises, Stephen Schwartz. Stephen Schwartz est le Stanley A. Star professeur distingué de droit et des affaires à Duke University, qui est classé parmi les 5 facultés de droit les plus prestigieuses des États-Unis. Il est également le fondateur et dirigeant historique du Centre des marchés financiers globaux et interdisciplinaires de Duke. Ses domaines de recherche et d'enseignement sont le droit de la faillite, la finance internationale, les marchés de capitaux, le risque systémique, la gouvernance corporate, le droit commercial. Stephen est diplômé d'ingénierie aérospatiale, summa cum laude, c'est-à-dire mention les plus grands honneurs, et détient un doctorat en droit de Columbia Law School. Avant de rejoindre le Duke, il a été associé en restructuring pour 2 grands cabinets d'avocats à New York, professeur vacataire à Yale Law School et à Columbia Law School. Il est un pionnier dans le monde de la sécurisation des actifs, professeur invité distingué auprès de plusieurs grandes écoles sur 3 continents. Il a témoigné devant le Congrès des États-Unis plusieurs fois sur les sujets variés, dont la régulation financière et le risque systémique. Il est également conseiller aux Nations Unies, expert à Davos. En mars 2024, il a reçu le prix du journal des juges commissaires aux États-Unis. Parmi les 10 universitaires les plus cités dans le monde, Stephen passe actuellement 3 mois de sabbatique à Paris en tant que chercheur invité distingué à Sciences Po. Il s'est parfaitement adapté à la vie parisienne. Il est un amateur de vin rouge avec quand même une petite préférence pour les vins de Bordeaux. Stephen, welcome to Paris. Thank you for joining us tonight.
Thank you. I always say I sound better in French than in English.
Jonathan Seymour. J'ai également l'honneur de vous présenter Jonathan Seymour, qui nous rejoint par visio, comme vous voyez. Jonathan Seymour, il est professeur agrégé à la faculté de droit de Duke University, un érudit du droit de la faillite et de ses institutions et procédures. Plus récemment, il a écrit sur la façon dont la culture juridique particulière développer une application du Chapter 11 aux États-Unis influe les réorganisations des grandes entreprises, se demandant si le droit de la faillite et les tribunaux compétents devraient fonctionner si différemment du reste du droit. Jonathan est titulaire d'une licence en droit allemande à Oxford et un doctorat en droit de la faculté de droit de l'Université George Washington. Il a rejoint le corps professoral de Duke en 2022, après avoir occupé pendant 3 ans le poste de professeur adjoint invité à la faculté de droit. Avant d'entrer dans le milieu universitaire, il a exercé en tant qu'avocat plaidant en matière de faillite au cabinet WilmerHale à Washington, où, entre autres, il a participé au litige de plusieurs affaires de faillite devant la Cour suprême des États-Unis. Jonathan est également francophile et il vient en France chaque année pour animer un séminaire dans le Gers pour les chercheurs juniors de la faculté de droit de Duke. Parmi les questions plus tard à poser, on peut demander pourquoi la Gers. Jonathan, welcome and thank you for joining us tonight. Maintenant, je passerai le micro à notre modératrice, Maître Céline Domanger-Morin.
Merci. Pardon, j'ai la chance de jouer avec les micros pendant toute la soirée. Vous m'entendez? Non. OK. So hello everyone. So we will switch in English, I think, for the rest of the conference. So Christophe Temno will be, we say, the French guy with Patrick Sayer on this table, and we will try to go into the detail of the different points, comparing some issues that were discussed lengthily in the US, and the idea of this conference today was maybe to hear from Stephen and Jonathan, who have written a very excellent article, I would say, on the absolute priority rule and the comparison with the EU directive and the relative priority rule. I think it is something that will be very interesting for us. We are at the beginning of the case law for us of this new insolvency law. And the idea today is to have 2 parts. The first one will be some speeches, I would say, of Patrick Sayer, first an introduction on the directive, and then Stephen, Jonathan, and Christophe. And then we'll have a long debate, I hope, with all of you in order to answer to different question, and not only of the absolute priority rule, but probably deep financing or any other question that you may have regarding Chapter 11, in order to see what we can take in terms of lessons for us for the new 50, we say, the next 50 years of application of our insolvency rule. So first, maybe Patrick, if you can tell us a few words about what you think about this new insolvency laws directive. Yes.
Good evening to everyone. It's an honor for me to speak about classes of affected parties in France, especially given the fact that I do not have the qualifications to be talking about them. Having left the safeguard chamber of the Paris Commercial Court in 2020 to devote myself to litigations in the corporate law and financial law chambers thereafter. But I'm pleased to be taking part in this debate this evening, given the fact that the preparation of it has enabled me to become more familiar with the legal provisions relating to this area of insolvency law, whose recent introduction into positive law contrasts with decades of different practice. To some extent, I had experienced the matter when I was a banker in New York, working for a firm which at the time had one of the most renowned practices among American investment banks. And as head of the telecom and media practice, my team was from time to time confronted with massive restructuring, such as the one of WorldCom, for instance, in which my restructuring partners were deeply involved. On this occasion, I encountered for the first time as a French the practice of different classes of creditors and the importance of conventional subordination in structuring a reorganization plan. After leaving investment banking to enter the world of private equity, I happened to be also confronted with a major restructuring in Germany, a German parking company called APCOA, for which the size of the acquisition debt in relation to cash flow had driven into bankruptcy. Despite our efforts and our willingness to participate in the restructuring of the company as a shareholder, the German legal system laid down a principle of equality of creditors. That system also provided, as my friend Richard would say much better than I, that advances granted by equity holders were in fact subordinated to unsecured claims. As soon as a debt fund positioned itself to take over the company by buying pieces of bank debt, the shareholder couldn't do a thing, which happened to be our case, and we lost quite a lot. Then, as a young judge at the Paris Commercial Court, I discovered insolvency law and was confronted with the previous regime, which was based on the creation of creditors' committees. We all know the limitations of these committees, as they were set up based on the quality of the creditors rather than the nature of the claims held, giving certain unsecured bank creditors more weight than other creditors, even though the latter were preferred creditors. The restructuring of Thomson Technicolor has been a good example of the difficulties that have been encountered in reaching a satisfactory solution. I was therefore personally delighted that the European legislator had shaken up insolvency law, as some authors rightly consider that insolvency law used to be, or remained for too long, the poor child of European business law. Of course, we all know that one of the particularities of insolvency law is that it touches on so many branches of law, not only company law, also civil procedure law, labor law, but also civil law in the wide sense, such as property law, surety law, family law, and others. In civil law systems, pillars of the whole edifice are therefore to be redefined, hence the natural reluctance of member states. But one could not be satisfied with the status quo, which endangered so many companies in the name of the selfish interest of a few, driven essentially by their situation and leading companies in the disastrous scenario of compulsory liquidation. And therefore, I was saying we can only welcome the transformation of the European insolvency law, progressively transposed in our national system in a three-stage that I guess all of you know. First, the time of the 2017 ordinance, then the directive of June 2019, transposed in our positive law by the ordinance of September 15, 2021, which, without upsetting the physiognomy and the balance of the matter, operates a transposition a minima, since the text left to the member states great flexibility in the transposition of its provisions. Then, as you know, there is a new text which will be coming into force, which is Insolvency 3, and we will soon be involved in the transposition of it. To understand the scope of the text on classes of affected parties, we need to start with the 2012 Union communication, followed by the March 2014 recommendation, which expresses the need for member states to equip themselves with a preventive restructuring framework for companies, enabling them to restructure their business with the aim to prevent their insolvency. Some might think that it's a simple semantic shift. It is much more for the European legislator, and it's based on the principle of not allowing an isolated creditor or group of creditors to oppose the restructuring of a company to ensure the company of the business project and the preservation of jobs. We all know that this recommendation was insufficiently followed by member states, leading to the proposed directive of November 22nd, 2016, which already mentioned the principle whereby the adoption of a restructuring plan could be voted by classes made up of the debtors, creditors, and on option, the holders of the capital. It was with the 2019 directive that the notion of classes of affected creditors really made its appearance, with the preparation and implementation of a restructuring plan designed to prevent the insolvency of a company based on a consultation of creditors within classes under the supervision of a judge, and above all, the possible imposition of the plan on certain recalcitrant creditors or even classes of recalcitrant creditors through the application of the cross-class cram-down with respective subordination agreements predating the proceedings. We are at last getting to the heart of the matter and facing up to it, which was done by the Ordinance of September 15, 2021, transposing the European Directive into the Book 6 of the French Commerce Code. No doubt anxious to get ahead of itself and risk inconsistencies between a mechanism inspired by American law, which German law had already borrowed, the report to the President of the Republic stated, using the freedom left to member states by Article 2 and 9 of the directive, the ordinance does not create a rigid framework for the constitution of classes of affected parties. I think it's very important because it's really the center of the matter that we'll discuss later on. Fundamentally, and this undoubtedly distinguishes it from American law, it was through the accelerated safeguard procedure that the regime of classes of affected parties made its forced entry into our code, eliminating the disappearance of the subtle distinction between accelerated safeguard and accelerated financial safeguard by a merger of these two regimes. Admittedly, the system of classes of affected parties also entered the traditional field of receivership and more recently that of ordinary safeguard, but these provisions are only compulsory above certain thresholds, and some thresholds which are in fact modest, at least to our American friends, as they are used to restructure on a larger scale. Why do I make this distinction? Because in the US, the situation of a company in Chapter 11 is not detrimental, to the contrary, to its economic activity. Whereas in Europe and in France in particular, the stigma that has historically surrounded bankruptcies, whose debtors were not so long ago thrown into prison, leads to a reluctance on the part of the partners of a company in safeguard or reorganization to maintain or even develop their business relations with that company. As a result, the preferred framework is in fact a confidential conciliation, which is an essential element of the preventive procedures in France. You know that we have two, with the organization of the plan taking place on a confidential basis and making it possible to reduce as far as possible the period during which the company will effectively be in safeguard procedure, i.e. non-confidential, through the so-called accelerated safeguard procedure. The abolition of the former creditors committee and their replacement by classes of affected parties is based on a test that is simple in its definition, but sometimes more delicate in its implementation, namely the situation of each creditor regarding the nature of his claim and his chance of being paid in the restructuring process. To leave the floor quickly to my comrades, and I think I've already been too long, I won't repeat all the legal criteria that related to the regime that you already know, but I will make just a few observations. One, on the one hand, the compulsory consultation of classes, which is based on size threshold criteria in safeguard and receivership cases, incorporates, and this was necessary in my own view, the notion of group of companies. I don't know the equivalent of the principle of the autonomy of the legal entity, autonomie de la personne morale in American law, but I must say that French judges have sometimes been relatively short-sighted in not taking into account the fact that a given company belongs to a larger group. It seems to me essential to integrate the notion of group more generally into amicable and collective proceedings. Second, the status of affected creditors, i.e. creditors whose rights are directly affected by the draft plan, according to the law, is by the tautological nature of the definition subject to interpretation, and therefore encourages its clarification by the judge. And we, as you said, Céline, we have just the beginning of some case law on the matter. 3, while shareholders do indeed constitute a class provided for in the law, there are several questions, some of which have already been settled on appeal. For instance, the matter of convertible bonds, the matter of bonds which are redeemable into shares, as well as the largest matter of securities giving immediate or future access to equity. And I have not mentioned the very French debate on the status of usufruitiers, usufructuaries, compared to new propriétaires. My God. Well, I guess you've understood. Which is a very French debate, but it has its implication. It could have its implication if a company where the equity is effectively divided runs into this kind of situation. 4, French law, which is concerned with protecting the interest of its employees, has not made the employees as a separate and autonomous class. I, for one, would be curious to know the involvement of employees in American law. And 5, and I will finish by that, the administrator benefits from a certain discretionary power to affect the rights of certain creditors, who thus cannot be qualified as affected creditors. Of course, this power must be justified, but what are the limits which the courts will put on it? At this stage, it's too early to draw any conclusions. Some authors have suggested that in the event of a cross-class crampdown, a dissident class of creditors could invoke non-compliance with the absolute priority rule if a class of equal ranking or subordinated creditors had been artificially excluded from the scope of the restructuring. What indication does the US law give us, given the fact that the constitution of classes is not the responsibility of the administrator, but the one of the debtor? In this last question, I have, as you've understood, raised the issue of the absolute versus relative priority rule. As said earlier, the rule here is subject to derogation, subject to the judge, the administrator, and then the judge discretion. How wide can the discretionary power be? In the few cases that we've had in France, most of which have not yet made their way to appeal courts, there is not full clarity, to say the least. And I'm sure that Counsel Céline Demanger will remind us in a minute, and no doubt that Professor Schwartz will highlight the learnings of 50 years of case law in the US on that topic. Thank you very much.
Thank you, Patrick. So now I think we will just listen to Stephen Schwartz. Maybe just to explain first that, as I said earlier, you will just all receive an article that have been written by Stephen and Jonathan called Corporate Restructuring under Relative and Absolute Priority Default Rules, a Comparative Assessment, which is in fact a view based on the American experience of why absolute priority rule is very important, and especially if you want to develop some consensual restructuring. So quite interesting for us after years and years of development of our, I would say, mandat ad hoc and conciliation proceedings. I would just quote, if I may, a sentence from this article that I think is very interesting, which is that, as in many other areas of the law, the Bankruptcy Code recognizes that within a properly structured framework, parties may reach better outcomes and should do so in more efficient fashion if they resolve a dispute on their own terms than via adjudication. And I think it is exactly what Stephen Stephen will explain. And I think it is really very interesting for us, and especially to debate then, I think, on our first case law under French law. So first, my first question for you, Stephen, will be, the goal of the EU directive is to facilitate the consensual reorganization of inherently viable but financially troubled firms. So shouldn't it be easier to reach consensus with a relative priority rule which is more flexible, rather than with a non-flexible absolute priority rule?
Can everyone hear me? Thank you, Celine, and thank you, Patrick. So before I answer that, let me just mention two things to give perspective. One is terminology. The term cram down is traditionally used in France, I gather, to recognize what in the States, in the Chapter 11, we would call supermajority voting. And that is, within a class, it would be a vote of the class that would bind dissenting members of the class. The EU directive essentially goes further, and the question is, if you cannot reach a consensual reorganization, it sets forth the various classes and provides a mechanism whereby the plan can be crammed down over objection of one or more classes. And that's called cross-class cram down. Jonathan and I, in our paper, used the term cram down in the American sense, which would include cross-class cram down. So when we say cram down, we include cross-class. Second thing I should mention is that although the EU directive does, according to the possibility, set the absolute priority rule as the basic rule, it turns out under the cases, and Celine could probably discuss this more than I can, there's a judicial trend in France to be very flexible on the exceptions, and there are many cases that use the relative priority rule rather than the absolute priority rule. So let me try to now respond more directly to Celine's question, and that is, why would an absolute priority rule actually give more flexibility than a relative priority rule? And that sounds counterintuitive. And the reason is that, as Celine mentioned, the objective in a reorganization, ideally, is to reach a consensual reorganization plan where all the classes decide this makes sense for them. The only way to achieve that, certainly if you have an insolvent debtor, is for senior classes to give up value to more junior classes. And so you want to provide incentives for them to do that. You want to provide incentives for basically parties to compromise. What absolute priority does under Chapter 11, it says that if you don't reach a consensual plan, there is a default rule. And this default rule imposes a penalty. So I describe it as a penalty default rule. And it says that you go to a cram-down procedure in which you have to precisely value the debtor so that under the cram-down, you could determine that what is being given to each of the classes is fair and equitable. Now, the reason this is a penalty is that the valuation has to, because of its precision, is impossible to reach, or virtually impossible. Okay? There are two ways to value companies: discounted cash flow and comparable company. Neither of these can really be done for a company coming out of a reorganization when you don't know everything that's going to happen. And so parties litigate, sometimes for years. And guess who pays the litigation costs? It's the parties, the creditors. They lose money. And rather than losing money on this major litigation, now mind you, for the lawyers in the house, that's a good thing, but for everyone else, society, it's a bad thing. Rather than losing money, they have an incentive to compromise. This valuation procedure under absolute priority has been described as a joke, as an estimate compounded by a guess. In other words, it really is quite imprecise. So the idea that you have the penalty default rule as a way of encouraging the consensus, that's what you want. Under relative priority, whatever that actually means, and it's not clear, there certainly is not going to be a precise valuation of the debtor, and therefore you don't have the same penalty default rule.
Thank you. So, is the relative priority rule fair? Why doesn't the best interest of creditors test adequately protect creditors whose claims are crammed down?
Okay, so the relative priority rule would, we, meaning Jonathan and I, believe would permit unfair outcomes. It would permit shareholders to retain much of the value, or at least a significant portion of the value, in a reorganization, even if you're talking about an insolvent debtor where the shareholders, if it were liquidated, debtor were liquidated, would receive nothing. And this could make debt investments in the EU, even more difficult. You also have the possibility that in order to reach a restructuring plan that's approved, you have the shareholders propose a plan, I'll talk about that, and a senior class approve it, and that means that intermediate creditors can be squeezed out. It also encourages what economists call morally hazardous behavior, and that refers to behavior where the party who's acting, doesn't bear all the consequences. So you have that possibility. Now, you do have the protection under the EU directive of the so-called best interest test. The best interest test, at least initially, is modeled on the Chapter 11 best interest test, which is under Section 1129A7 of the Bankruptcy Code. And that's a very minimal test. It only requires that each objecting creditor receive at least what it would receive in a Chapter 7 piecemeal liquidation of the debtor. There is an explanation in the EU directive that suggests that this best interest test might not be limited to piecemeal liquidation. It might include, for example, liquidation through a sale of the business as a going concern, or it might include some next best alternative scenario. But which way it comes out is not yet clear. And certainly, if the best interest test is going to follow the American Chapter 11 test, that you receive at least what you get in liquidation, that is a very low standard and not a protective standard.
Which is the same for us, to be clear. So, under the EU directive, the debtor itself has a virtual monopoly over proposing a plan. How does it compare with Chapter 11 and cram down?
Okay. Under Chapter 11, and there are various similarities between Chapter 11 and the EU directive. One, of course, is that control over the restructuring is given to the debtor, and that's especially true in SME, small, medium-sized enterprise cases. It also has a stay of collection. It also requires counterparties to perform the debtor's unexpired contracts. But the problem, or the main difference between Chapter 11 and the EU directive in terms of the debtor's monopoly control over the restructuring plan, is that under the Chapter 11, this monopoly power can be taken away from the debtor under various circumstances. For example, in theory, if the debtor doesn't propose a plan that's accepted within a short period of time, relatively short period of time, the court has the ability to terminate the exclusive period. Now, I say in theory because I've practiced bankruptcy law, and I know that whenever you make a motion to the judge to terminate the exclusive period, the judge almost always turns it down, but at least you have the theory there. Another reason, probably more importantly, is if the debtor doesn't propose a plan that is accepted within a reasonable period of time, creditors can move under Section 1112 of the Bankruptcy Code, Chapter 11, to convert the plan from a Chapter 11 reorganization to a Chapter 7 liquidation. And so the threat of liquidation is always there. And these threats essentially are what motivates at least the debtor, to propose a consensual plan that it believes will be reasonable, that it believes will encourage even creditors who have to give up some value to agree to that, because giving up that value is going to be better than the alternative.
Yes. So my last question for you for this first part would be, what does relative priority even mean? The EU directive does not explain what will be sufficient to satisfy the requirement that senior creditors be treated more favorably than junior priority creditors or shareholders.
Yeah. So the EU directive is silent on what will be sufficient to satisfy the requirement that senior creditors be treated more favorably than junior creditors or shareholders. And there are various possibilities. The most logical possibility would be that the senior classes would receive a higher percentage of recovery than a junior class. So as between, let's say, a class of senior claims and a class of junior claims, that would be satisfied if, for example, the senior class receives 75 cents on the dollar or the euro, and the subordinated creditors receive 70 cents, something slightly lower on the dollar. But it's even less clear what treated more favorably would mean if you're comparing not merely senior to junior creditors, but senior creditors, junior or subordinated creditors, and shareholders. And under a relative priority plan, for example, a debtor might propose a plan that gives 40% of equity in the reorganized company to the senior class, 35% to the subordinated class, and as much as 25% to shareholders. So the seniors receive higher percentages. Would that work? Apparently it could work. We'll see what the case law says. And that certainly sounds unfair if you have an insolvent debtor. You, of course, don't have the necessity for evaluation, so it really is hard to say what it really means.
Thank you, Stephen. So now we'll give the floor to Jonathan. I think the idea now is to maybe, because we know that we have a lot of debate in France at the time around, I would say, the treatment of the large matters compared to the small one, and especially due to the fact that we have a threshold under which you have no cram down against the shareholders, and so you may have different rules applying, whereas we're talking about the same insolvency law. So the idea that we had today was also to make a specific focus on small and medium-sized company with the assistance of Jonathan. We have not only written about the different priority rules with Stephen, but you have also examined how the size and nature of the troubled company can influence its successful reorganization under Chapter 11. And so I would say, what differences, exceptions are given to small company cases in the US, Jonathan?
Yeah, so thanks very much, Celine. This is something that the US really struggled with for quite a long time. In the last 5 years, we've had new legislation that creates a subchapter 5 of Chapter 11, specifically for small businesses. And the consensus seems to be that it's working actually quite well. So this is an optional and quite different structure to regular Chapter 11. By small businesses, Congress mostly just uses a debt limit to determine who qualifies. So there are a couple of other non-material limitations. But for the most part, going forward, a business with less than $3 million in fixed liability, so liabilities excluding unliquidated or contingent debts, qualifies for new subchapter 5. The rough estimate, I think, is about 40% of business debtors by number will qualify. And it's just a debt limit. We don't look to the assets of the business. We don't look to the number of employees or anything like that. So I'll say a couple of words about the kind of baseline before we got subchapter 5 and the problems that the US was experiencing. Then I'll kind of describe this new solution and in particular how it approaches absolute priority. So Congress's original concerns really in the small business context were about kind of inefficient continuation. So businesses that had little hope of recovery using bankruptcy to try and delay liquidation to the ultimate cost of creditors. You know, they seem very taken with the kind of image of the starry-eyed entrepreneur who believes in his heart that he can turn the business around even when the facts are not on his side. So pre-2019 law made some effort to keep costs down for small businesses by saying, you know, the court can say no creditors committee is required. The court can combine hearings on different matters into one hearing. But mostly it was trying to intensify judicial scrutiny and to speed the debtor along through this process by setting very tight time limits. And the end result was very high rates of liquidation and low rates of confirmation of plans of reorganization. So something like 70% of debtors made no effort even to try and reorganize. They just, the small business debtors made no effort to try and reorganize. They just went straight into Chapter 7. Subchapter 5 coming in 2019 streamlines the process further, dispenses with a disclosure statement in which the debtor details its proposed plan to creditors, dispenses with the creditors committee. It also gives the small business debtor total exclusivity. So it is the only party that can propose a plan throughout the case. But it sets that off by appointing a trustee in every case. So the trustee does not replace the debtor's management or run the business. They have kind of an oversight role. They advise the debtor, and they also have standing to raise with the bankruptcy court any problems they see with the case. I think the kind of biggest change is that although the debtor may pursue a consensual plan just as before, there's a new option for cram down plans that includes an alternative to the traditional absolute priority rules. So the goal is to provide a pathway for the debtor's shareholders to retain all of the equity in the business while still providing a fair recovery to creditors. So absolute priority in these new style cram down plans continues to apply as between all classes of creditors. Junior creditors can recover only once senior creditors are paid in full. But the debtor or the debtor's shareholders may keep all of the equity in the business if they propose a plan under which they pay 3 to 5 years of all of the debtor's projected disposable income to creditors going forward. So projected disposable income means the debtor's calculation of all of its revenue for the 3 to 5 year period, less any expenditures necessary to continue to operate the business. And the theoretical construct is that the debtor's shareholders are buying back the equity over this 3 to 5 year period via their payments of disposable income. If the debtor doesn't make these payments, the case can be dismissed and creditors can enforce their claims as usual. And the best interest test also applies. So every creditor must recover at least as much as it would in a Chapter 7 liquidation. In terms of evaluating this, we have some measurement difficulties because the law became effective only in February 2020, so immediately before the whole landscape changed due to the COVID-19 pandemic. But the results do seem to be very positive. So there's a recent paper estimating that businesses are close to 40% more likely to reorganize if they use subchapter 5 as compared to if they use the traditional chapter 11 structure. And also that they get to confirmed plans much more quickly, perhaps as much as 30% more quickly. And all of this is happening without actually negatively impacting creditor recovery rates. There's some evidence, in fact, that it might even have increased them.
Okay. I think what is interesting, because I'm not so sure that everyone hear the fact that the threshold, if I'm right, is 3 million, which is quite low. So how the US faced problems in implementing this subchapter 5 that might be instructive for other countries that are considering small business bankruptcy reform, because the threshold I was talking about regarding the difference for us between companies where we have a possibility to cram down on the shareholders is much higher in France. That's the 3 million euros, $3 million that you were talking about for your chapter 4.
Yeah, so the debt limit has been the real kind of point of controversy over subchapter 5. It's actually currently more than twice, what is, it's currently $7.5 million. That was a temporary increase that Congress passed, kind of anticipating increased resort to subchapter 5 as a result of the pandemic. Practitioners' attitudes tend to be not just that the current debt limit of $7.5 million, which is going to go down in about 2 months to $3 million, is working well, but in fact that it could be and should be much higher than that. The problem, at least politically, is that there's a kind of trade-off between the maximizing the power of the tools that we give to small business debtors and maximizing access to those tools. And there's kind of little political appetite to provide this pathway to retain, all equity in the firm to shareholders that don't kind of meet the kind of model of the closely held entrepreneurs managing really very small businesses. In particular, if you think about subchapter 5 as providing that the price that the shareholder can buy their equity back in as being 5 years of the business's disposable income, it's likely, I think, to be the smaller, closely held businesses where there aren't significant assets, where actually the real value add to the business is the entrepreneur's individual kind of skills, knowledge, network connections, and so on, where that deal makes sense, and creditors are likely to be less willing to accept that deal when we're talking about businesses that are significantly larger than that.
I think Stephen wanted to comment.
Absolutely terrific and correct. If France were to try to enact something similar to the subchapter 5 of chapter 11, it would involve a new political process, and that may or may not be feasible. Assuming it's not feasible, and this is a comment for Patrick and his judicial colleagues, there actually could be a way to really keep the absolute priority rule in place and not have to go to a relative priority rule, but still enable managers and owners of small businesses, SMEs, to preserve equity value. And that would be, in the U.S., there's something called the new value exception. It's unclear the state of its validity currently under U.S. law, because the language of Chapter 11, 1129B, is rather ambiguous. But this is a judicially created concept. And the concept is that you can have an exception to the absolute priority rule if an existing manager/shareholder would contribute value to the company in the reorganization for some period of years. Let's say they work for the company for some years at a reduced salary or contribute something else. And this could be enacted not through legislation, not through an EU directive, but really through judicial determinations as it is formed in the United States. So I just want to suggest that as a possible option that would be consistent with keeping the absolute priority rule in place.
So again, maybe another question for you. A primary argument for relative priority rule is that it enables key manager at SME to retain significant equity in their firm, thereby encouraging a successful reorganization. I understand from Professor Seymour that that discuss the new small business reorganization provision of Chapter 11, that there is this exception. But might there be other ways to allow key managers to retain some equities than just this specific subchapter 5? Maybe let's focus for a few minutes on France. And I think Christophe may explain to us, I would say, make some focus, I think, on some different matters. Our first case law, I would say, with different type of case law, I would say the maybe some large matters where I think you want to discuss about Orpea Casino, maybe, if I remember correctly, but maybe also some smaller matters, and maybe to give, I would say, a sort of state of where we stand on these different issues and why we consider that we have a sort of debate, especially on this question of the absolute priority rule. Christophe?
Yes. So good evening, everyone. I'm very pleased to be able to speak in front of you, all of my friends and colleagues. Maybe I would like to react a little bit and say some words about the absolute priority rule as the penalty default rule, as you explained, Professor, and its impact on negotiation dynamics. And we all know that in negotiation theory, what is the alternative is the main question. This is what you explained, yes, for senior creditor to be able to give up value, and so they are incentivized to negotiate, and in your view, for senior to give up value to junior because they don't want the uncertainty of a valuation outcome and the length and the cost and so on. And my reaction is that we know in France, we know well this phenomenon, and since 2005, when the creditors committee were created by the law, because it changed the dynamics of negotiations in pre-insolvency proceeding, mandat ad hoc and conciliation. The change was that into the pre-insolvency, you needed 100% approval for any plan from all stakeholders, at least the stakeholders that were put into the negotiation of the conciliation, where the new safeguard with creditors committee that was created needed a 2/3 majority. And then when we started to experience that, and quite quickly, the parties were more willing to reach an agreement and not facing the risk of being outweighed by a majority of 2/3. So we know of this phenomenon, and at that time, before the classes of creditors, classes of affected party, we only had 2 committees, secured, unsecured, or financial committee and suppliers committee, which was not totally satisfying. I have another reaction on what you mentioned, what you said about the European Union choice to let member states to set into the system of law the relative priority rule. And my understanding or my guess, because I was not involved in those discussions, to let member states apply the relative priority rule is probably to address exactly what the subchapter 5 that was mentioned by Jonathan addresses. Because if I understood well, this subchapter 5 let the owner manager of a small and medium-sized company, which is very important, to keep their business while they are imposing efforts and sacrifices on creditors. So I understand that the US gives the absolute priority rule exceptions, in that case at least, and I also understood from our talks prior to the meeting today that there was also an exception where the debtor could be allowed to pay suppliers, strategic suppliers, needed for the day-to-day business, which is something we don't know in France, at least, maybe in Europe. And this is another exception of the absolute priority rule. Then, to my view, there are two questions. Should the relative priority rule be possible in high-hand cases? And you say no, it should not, but I raise this question. Should it be possible in high-profile cases, or should it be forbidden? And the other question would be, to me, is it fair? And we know that fairness can have lots of meanings. Is it fair that an intermediate class of affected party, partially in the money, so not the senior class totally in the money, not the junior or the shareholder out of the money. So is it fair that this intermediate class can be squeezed out when the senior class decides so, because they have the power to decide, while the junior class and the shareholder, the equity, still get value? Which is the question you just raised. And my answer to that question is that I don't think it's fair. And it's not fair, and it's not predictable for all the constituencies. And we know that uncertainty does trigger decision-making, whatever the decision is, working with someone, investing into the company. And what I retain from your suggestion is that maybe for SME, small and medium enterprise, we should be more cautious about applying in the judgment in courts and within my colleagues and the whole restructuring ecosystem here to apply the absolute priority rule, with the exception of the shareholder owner in small and medium enterprise. We had, I am not running out of time, you tell me, Céline, we have two recent cases that raise this question on the full use of the relative priority rule. The Unicos case, which was held in the Tribunal of Pontoise, where, to my understanding, I read the judgment and the plan, the outcome is exactly the same as a sell plan. It's a sale of the company, but the shareholder remain untouched. The equity is not impaired by the plan. And the Tribunal of Pontoise granted exceptions to the absolute priority rule, stating that there is no better alternative if the plan was rejected. So that was the mean for the court to accept this exception to the absolute priority rule. On this case, it must be, because I heard a lot of criticism on this case, but it must be added that there was a prior sale process. My colleague, the IP, tried to find purchaser, new owners, with no results. No one wanted to buy out the company, with no debts. So, and a prior negotiation with the banks, where there were no classes of creditors yet, failed too. And so they took this final approach of setting up the classes of creditors to get the vote and squeeze out the intermediate class, which was not maybe the best way to do so. We have another case that was in Lyon, Tribunal de Commerce de Lyon, which is called the fitness SIA case, where this time the plan was rejected by the tribunal because, according to the judges, the best interest test was not proven. So they challenged the experts' reports. And they denied to grant the exception for the absolute priority rule because they said these exceptions only leads to get a positive vote from a specific class. To put that in other words, it was a kind of a scheme. It was not written like this, but it's the spirit. On this case, out of 15 classes of affected parties, 3 senior classes in the money were receiving 100% of their claims and voted for the plan. They said yes. Where the remaining classes, the 12, got only 10% in cash immediately, meaning 90% write-off. And there was a classes of bondholders who got shares in lieu of their converted bond. And I don't know in the decision what percentage they got by this debt to equity swap. Maybe not 99%, maybe 50, maybe 60 or 40. Yeah. I don't know. And again, in this case, on first instance, the public prosecutor was against the exception to the absolute priority rule because, I quote, the adoption of a plan cannot be the result of blackmail, which was very strong as a statement for the public prosecutor. There was an appeal on this case, and the appeal court ruled that the best interest test was passed positively because in the meantime, valuations have been provided. And that was another question you raised, but illustrates another question you raised. You need valuation at some point when there is no agreement. And the appeal court also said that the exception to the absolute priority rule is necessary to fit with the plan accordingly to the law, meaning continuity of business, job saving, and debt decreasing, which is quite strange because the law says debt payment. Yeah. And the Court of Appeal said it decreased the debt, which is not exactly the same. Do I have 3 more minutes? 2 minutes. No, just to illustrate another high-end case, casino case, and I'm not going into deep details of this plan because some people in the room might know much better than me what happened in the case, although my partner, Aurélia Perdereau, was in charge with her colleagues. But to describe it at large, there was a massive conversion of debt into equity. There was also massive commitment to provide new funds. And there were also reinstatement. Does it speak to you? Reinstatement of, let's say, RCF, revolving cash flow lines. Mm-hmm. And instead of being paid, my understanding of the plan is that the RCF stays for another 2 or 3 years. So I'm not sure if it's paid and reinstall or just reinstall, but anyway, this is financing.
So RCF is revolving credit facility, or what is that?
In fact, the idea was to keep the RCF, to consider that it was, in fact, a counterparty of granting some operational facilities, and by keeping the RCF, it was a way not to be converted into equity, so it was reinstated. Yeah.
And so the last question on the casino case is, were they an exception to the absolute priority rule? The answer is yes, but a very thin one, to my view, because out of 7 or 8 classes, there was one class who did not vote, and there was only one creditor in the class. He was the only one. And so this class did not vote against the plan, they just did not vote. And so because of this reason, it was there was a solution must be found, and then the court said that because this class did not vote, we have to impose a cross-class cramdown, and so divert from the absolute priority rule. Maybe there was another reason, but it is not into the ruling, into the judgment, is that in all the massive debt to equity swap that I mentioned, we talk about 6-7 billion euro converted. The equity, the shareholder, retains a very, very small percentage of their equity. No, but I was saying that the equity remain very little part of their value, something like 0.1% after all the transfer. So this is my say on the subject, but again, I like very much the idea of having a cautious approach of the relative priority rule for our small businesses. Thank you.
Thank you, Christophe. So it is time for debate, and if I may, I will have the first question for Stephen, which is in fact quite a broad question, but I'm sure that Stephen will be able to answer in 5 minutes, which is, given the close to 50 years of experience of US Chapter 11, are there an interesting example of how variation from the written law have led to excesses or unanticipated consequences? And if I may, I would like to hear about gerrymandering, because I think it is something that was closely, I would say, mentioned by Christophe, due to the fact that in the different case laws that were mentioned, there were many classes.
Okay, so let me respond to the many classes. Of course, the debtor has the ability to limit on how many it can designate or how it could break it up. The only restriction is that, well, only relevant restriction right now is that all parties within a given class have to have substantially similar claims, which at least means that those claims are pari passu, that is equal and rateable. So what would be the incentive of a debtor to create many multiple classes? Usually a debtor would not have an incentive to artificially create multiple classes, because each class could veto the plan, and that would then send the only way the plan could be confirmed would be under cram down. So the absolute priority rule under cram down is an incentive not to artificially split the classes. In terms of the Chapter 11 sort of things in Chapter 11 that were different than what was originally contemplated, let me briefly mention 1 or 2 or 3 examples. Probably the most interesting example, I think, is so-called equitable subordination. Prior to the bankruptcy Chapter 11 being proposed, there was a limited exception whereby a bankruptcy judge could use its equitable powers to subordinate claims. And this came up in the case involving a so-called deep gap case, where you had a parent company that has subsidiary, and it was keeping the subsidiary on minimal, life support, financial life support, and there were some intercompany claims that the parent had against the subsidiary. The subsidiary had various independent claims. The subsidiary ended up in bankruptcy, and the court said that the intercompany claims were subordinated equitably to the independent claims. That makes a lot of sense. And this concept was control plus inequitable conduct. Section 510C of the Bankruptcy Code, when it was basically promulgated in 1978, said that those principles of equitable subordination will continue. But because it didn't set out what they were, bankruptcy judges have gone crazy on various occasions to use what they believe is their unlimited equitable power. And Jonathan has written a wonderful article in the University of Chicago Law Review suggesting they shouldn't have this unlimited power, but judges believe they do have it. Okay, and so bankruptcy judges in various cases have been equitably subordinating quite valid independent claims against other claims according to their own notions of fairness. And that is not good. That creates uncertainty, and that is just very bad for the integrity of the system. Another variation is from Chapter 11, is that Chapter 11 contemplated that if you had a wholesale reorganization of a company, it would be under Chapter 11 and not under a section of the Bankruptcy Code 363 that contemplates the sale, use, or lease of property. But there have been cases in which judges have used 363 to essentially create what is sometimes called a sub rosa or secret plan. And probably the most egregious example of this is the General Motors restructuring after the global financial crisis. I'd be happy during the, when we have the drinks to discuss this with anyone, but it'd take too much time now. And just a third major difference that wasn't contemplated is that claims trading is becoming extremely common in the U.S. and probably outside the U.S. A claim, let's assume that you are representing or your client you have a claim against a company in bankruptcy and you want to get cash now, or you're not sure what it's going to be worth. There are hedge funds, there are so-called vulture funds that are offering you a fraction of the face value of that claim. And they are acquiring many claims and then using them to try to manipulate the negotiations for the deal. And this is a problem because Chapter 11 contemplated that the same parties that made the loans would continue and they would have an interest that would go beyond purely financial. But that is changing. So your former partner, Harvey Miller, described that as bankruptcy is becoming somewhat of a casino. Those are examples.
Thank you.
Let me just say
one
other thing, and that is, with Christoph, I just want to say that Chapter 11 is, in bankruptcy, federal bankruptcy law is great in the U.S., but we have one real disastrous mess, and that is we have 365C2, and this was a bank-lobbied provision that says that a pre-bankruptcy line of credit or financing is terminated and cannot be revived. So you had mentioned, I think, that under the revolving credit facility that was put back into place. That could not happen in the U.S., but I think it should happen under circumstances.
Thank you, Stephen. So we can spend the whole evening, I think, discussing about that. And again, I will insist on the fact that this article and everything you explained tonight just give us, I think, some tools in order to better understand what we can do and what we should not do in order to make sure that it will be an insolvency law that will be understandable and that will not create uncertainty and destroy value at some stage. And for that, I think that we understand this concept of the default penalty rule. And I think it's very interesting now that we have lengthy debate about what we should do in order to make sure that we will be recognized broadly as a jurisdiction where we have the ability to be understood by the different investors internationally. So I think we have some question about other issues because, and especially one I think that Douglas will ask about deep financing, because it is also another concept that we are discussing a lot when we are talking about Chapter 11.
And then we'll pass the microphone for those who would like to ask questions. But in fact, this question comes from someone who is here with us in the room, and I see them smiling as they're looking at me, but it's a little bit timid in English. So, French companies in bankruptcy have limited access to new financings to fund their operations during the insolvency procedure. As a result, the French government often provides liquidity support in various manners. This contrasts with the US, where debtor in possession or DIP financing and the DIP financing market is extremely developed. Could privately provided DIP financing improve the success of corporate reorganizations in France? What are the pros? What are the cons? And what would be needed to motivate private parties to consider providing DIP financing?
Jonathan, I'm happy to defer to you if you wish to answer it, otherwise I will answer it. I'm sorry?
That's fine.
Jonathan, can you hear me?
Yes.
Oh, yes,
So
I'm
you-
sorry. I was saying that I would defer to you to answer that question unless you would prefer I answer it.
So I can certainly speak a little bit about the U.S. You know, as Douglas says, you have an extremely well-developed market for DIP financing. You know, a DIP financing motion is invariably filed on the first day of a large case, with the exception that the judge will enter an order approving the DIP loan, at least on an interim basis, you know, within 24 hours or so. You know, this is possible in the U.S. because DIP lenders may receive super priority status, so ahead not just of the case's administrative claims, but also of secured lenders. It's under Section 364 of the Bankruptcy Code. To do this, the debtor must provide adequate protection to its existing secured lenders in order to be able to grant a new lien that is superior in right to them. So certainly DIP financing is, you know, extraordinarily useful in terms of providing liquidity for the case, and where the case is a kind of free-fall case in which the debtor doesn't have a pre-negotiated plan, giving space to the debtor to consider its options. You know, there's also been a fair amount of academic criticism. So in the US, the pre-existing secured lender is likely to end up being the DIP lender because it's difficult for the debtor to provide the adequate protection necessary to prime the secured lender, and get a DIP loan from someone else. And increasingly, DIP loans have been used by secured lenders to exert control over the case. So one type of control provision that's perhaps less troublesome is now very common, is what is called milestones. So in connection with the DIP loan, the lender will say, well, you must consummate a sale within 90 days of entering bankruptcy, or confirm a plan within 180 days of entering bankruptcy. And failure to do so is an event of default under the DIP. So I can cause the case to collapse if you don't meet my timeline. You know, I don't know how this translates to French. In English, we'd say there's an element of playing chicken here. You know, the debtor, I think, usually appreciates that the secured lender doesn't actually want the case to collapse, but it will at least prompt further negotiation if that milestone is tripped. The kind of more concerning type of control provision is when the DIP loan commits the debtor to pursuing confirmation of a kind of a specific individual plan that's been pre-drafted by the debtor and the DIP lender before the case is filed, and that you know, substantially constrains the debtor's kind of freedom of action, and you know, takes away the space for the kind of the kind of negotiated resolution that, you know, Stephen has described this as wanting, in which all parties are coming to the table and figuring out a deal in which you know, value is given up by everybody.
Sorry, maybe you have to mute, Jonathan. No? Ah. C'est bon? Ça fait un écho, non? Pardon. So I think, Christophe, you wanted to react regarding the fact that we are journalists saying that we would like to have a deep financing, but we are not so sure that we can do so. And I think you have maybe some analysis you want to share with the audience.
Thank you. Yes, I could have some thoughts about the question. The first one is that the new money financing does exist in France, whether it is at the stage of pre-insolvency negotiations, and there is a protection for the insolvency to come after that, and there will also new money privilege at the stage of the insolvency and for the plan. But when you seek deep financing, new money for a proceeding, of course the adequate protection for the existing lenders is certainly a threshold to pass, to overcome. And then there is the protection for the new money itself. As I said, we have the new money privilege in both pre-insolvency and insolvency, but there will, and especially in big cases with numerous of employees, we will always have a super priority creditor, which is the guarantee, the wages guarantee insurance, or not the company, but an association who gives the employee their wages when they are unpaid, and then they go first on everything. And so we know, because we discussed, and the people in the room discussed with the potential lenders, and they fear that even with very good protection and good security, the wages insurance will go first. And this is a real subject.
Yeah, so if I summarize, I think that it would be very useful to be able to have maybe a best ranking, and because at the time we are far from, I would say, the constraint and the leverage given to the deep financing that Jonathan was describing. I don't know if we have any other question in the room. We have some if you don't have, but we will be interested to have a question for you.
Yes, thank you, Professor Schwartz. It is extremely interesting. Thank you, Jonathan. One question about the constitution of classes. I don't know if you are aware, but we've had a precedent in France, in Orpea, where the Court of Appeal of Versailles had to rule on the constitution of classes, and especially on cross-holding, and that's what I'm going to. Cross-holding has been considered by the Court of Appeal of Versailles as a ground for putting creditors in different classes, even though they were at the same levels of subordinated creditors. In the Orpea case, it didn't have an impact on the solution, because basically they were the same. But it opens the way to the gerrymandering you were referring to earlier, or to an obligation for judges and for courts at the moment, and for judicial administrators at the moment they compose the classes, to take into account not only the objective status of the debt holder, but also the other elements that may lead them to take a different position. In Casino, in Orpea, the reason why they were separated is because some banks were also holding security debt and unsecured debt, and the court considered that it may lead them to have a position in favor of the plan because the plan was favorable to secured creditors. So basically, I don't know if this cross-holding has been recognized in the US as a reason for separating classes and how it has been treated, and I would be glad to have your views on that.
So you have a fair amount, when you say cross-holding, I assume, let's say someone who has both a debt claim and an equity claim, as an example, or a senior debt claim and a subordinate debt claim. We have, excuse me, very common cross-holding because under 506A of the Bankruptcy Code, an undersecured creditor, its claim is bifurcated into a secured claim to the extent of the collateral value and an unsecured claim for the deficiency. And that is allowed. I mean, that unsecured claim could be included with other unsecured creditors. You do have the concept that is not, and Jonathan, you may have some practical views because you've practiced more recently than I have on this, but there are many different types of creditors who have different interests. For example, banks and other institutional creditors, their interest is getting paid right away. They often would just be happy to see the debtor liquidated. Trade creditors, on the other hand, always want the company to survive because they want to continue to provide products and services. It is, I think, theoretically possible to put institutional and trade creditors in the same class because their claims will be pari passu, but in my experience, I've not seen that. I've not seen that done. There is another issue that ties into what you're saying, and that is where you have a creditor. Let's assume they have a creditor who has both a debt claim and an equity claim. If for some reason that creditor is being seen as not voting in good faith, that creditor's ability to vote could be excluded under 1126E of the Bankruptcy Code that allows a judge to determine that. So that is a possibility. Jonathan, did you have anything you would wish to add to what I've said?
So I don't really have anything to add. I'm pretty sure I have seen classes in which the deficiency claim has been classified by itself, separate from other separate from other classes of unsecured claims. But I don't have a sense of what is most common there.
That does a classification, and so it's rare that a court would try to reclassify.
Yep.
Stephen.
Thank you very much for the presentation. My name is Steve Portsmouth. I work for a French bank in the debt workout team. And I have a question for you, Stephen, because I was a little bit surprised and a little bit shocked by what you just said about, you used the word vulture funds, right? In France or in Europe generally, it's different from the US, right? The companies that we have tend to be 70% financed by banks and 30% by the capital markets. In the US, it's the other way around. So before I heard you, I mean, in my book, these non-bank creditors, if you like, or these non-bank buyers of distressed claims, actually perform a useful function in the sense that they come into around the table and they're actually prepared to deploy either fresh liquidity or fresh capital, i.e. through a debt-to-equity swap, which the banks are not, unfortunately, so willing to provide. So I was a little bit curious to hear you say that they can be a disruptive element in response to the question from Celine, and I was wondering if you could perhaps provide us with a little bit more colour as from a US perspective as to why you use that term and why you could see them as being sometimes disruptive.
Sure. Is this on? Okay. So it's not my term. It's It's an industry term, the vulture funds. They swoop in. The idea of they pick the pieces of a dying company. This does happen. Probably the best example of this, and you get into issues of how a vulture fund could have an impact. The bankruptcy code, the supermajority voting, or what you in France call the simple cram down, is intended to attempt to solve the collective action problem of one or more holdouts. And these vulture funds typically can act as a holdout. Again, they would come in, they see a company in trouble, they see it has creditors, they will offer a small percentage on the dollar or on the euro to buy claims of creditors. And let's assume they buy enough claims, they're going to try to get enough claims to block a supermajority vote under 1126C. So 1126C requires at least 2/3 in amount and more than 1/2 in number. If they can acquire, enough to block the more than 2/3 in amount, then they could block the vote on that class, the approval of that class, cause the plan to have to go to cram down, and no one wants that, and so they might be able to recover a higher percentage than their colleagues would get in the plan, or that's the intent. Now again, 1126C imposes the supermajority voting to get around that, and it could be hard to acquire more than, let's say, 1/3 in the amount of a given class, and the debtor has the ability to impede that by designating large classes. Where this problem is particularly difficult, actually, is not in corporate debt, but sovereign debt issues, because sovereign debt is not governed by the bankruptcy code. You don't have the supermajority voting, and their vulture funds are extremely active in acquiring sovereign debt claims and trying to impede a consensual reorganization. So I'm describing what is happening. I'm not naming these funds. I'm simply saying this is the reality.
Thank you, Professor Schwartz, Professor Seymour. Thank you for your presentation and discussions. A question regarding valuation. Given the experience you have in the US, is valuation today a concept which is mastered, meaning you have an evaluator coming and evaluating a business, an asset, and there will be no debate, or is it a source of long and painful discussions between parties?
It's a long and painful litigation between parties. Now, I gave a talk to the Lyon Law School this afternoon on this issue, and we discussed the possibility, which is not unknown in France, of the judge actually appointing an independent expert to engage in the valuation. And I think that would really, that could really help, because that would mean that if you do have to go to a cram down, at least you might have a realistic alternative to get the cram down done. But again, in the United States, we haven't yet evolved to that level. We have each of the different sides appointing their experts, and there are competing evaluations. I mentioned that the two methods are discounted cash flow, DCF, and comparable company. Neither of those is a perfect method, and in fact, Patrick's former colleague, Barry Ridings, and a bankruptcy lawyer, Peter Pantaleo, have written an excellent article, probably the leading article on bankruptcy valuation, showing why it is so difficult. And again, the U.S., it tends to be lead to extended litigation, which drains money out of the debtor, which means there's less money for the creditors and no money for the shareholders, and this is what provides the penalty default to incentivize them to try to reach a consensual plan.
Any other question?
Yes, I understood that the whole thing was to do so that capital market would be more interested into coming into this business of helping distressed or ailing companies or poorly funded companies. And I'm wondering, while I listen to you, how is this uncertainty that is now attached to all that creating the environment that will be attractive for people wanting to invest or lend to such companies?
So that's actually has somewhat of a compound answer but let me sort of cut through the different approaches. Let me just make two observations. One is, it was mentioned that in the US we have like about a third banks and 2/3 capital markets in the inverse in the EU. I know through the Capital Markets Union, at least the intention is to try to increase the percentage of capital market funding in the EU, and I've been involved with that to some extent. I'm not sure how that is going to affect the bankruptcy issues we're discussing today, though. It could go to the issue of DIP financing. Typically, DIP financing is provided by banks because capital market sources are a little bit harder to get organized. But I'm not sure there is a better answer. But Celine?
If I may, yeah. If I may, I think the idea was more to develop the capital market, and the idea was to limit as much as possible the uncertainty due to the fact that we have some insolvency laws that were difficult to understand for any institutional investors, especially coming from the US or used to the US. And I think that the whole idea about this penalty default is to say that if you have this absolute priority rule, it is something that is understood by anyone, and in fact, the rules. As much uncertainty you are creating, if you are not applying this absolute priority rule, you will in fact not develop the capital market, because people would be quite afraid by or concerned by the way it will go if finally the company is in distress situation. So.
I think this new money financing, DIP financing, is one of the most interesting cases around our reform. If we make a parallel between what you said and the situation here in France, is we don't have that many voucher funds buying just any claim, especially trade claims, just because trade creditors are not used to selling, first of all, and second of all, most of the cases are not big enough for them to get interested in. Second thing is DIP financing, when it's on the day of the opening of the proceeding, is not the majority of the cases, because we have a long existing culture of pre-insolvency negotiations. So most of the time the new money will come from people who are already interested, so either shareholders themselves or shareholders backed by new investors or creditors. But the debate around the valuation, the debate around the new money, the priority, etc., will most of the time, on large cases at least, have happened. And that's also the reason why maybe we observe, we were expecting a lot of litigation around valuation, and so far on valuation itself there has hardly been any, or any at all. So I think it's really interesting, and that's also in relationship with your question, Claude, which is your market is much more open to all kinds of financing, and I would also add on your point, Stephen, which was the banks at the moment in France hardly ever provide the new money. So I think there is an open case for equity or equity-like, let's call it DIP financing, even though it's a little bit different. So new money financing, and this is the position on the classes. And we opened in the very first conference we had a year and a half ago. We opened that question because new money by definition is not within the class, but it will move also the dynamics and the balance between the classes. And I think this is for the ARE, this is a subject which we will study closely, and I think which will also move the market, and a very, very interesting topic of this reform. And we also need to learn on your 50 years of experience on a much more mature market in terms of private lending, private funding, and we'll probably have that subject again in the coming years.
Thank you, Xavier. Those are points.
One last question. Sorry. Going back to something you mentioned earlier, which was the weakness of the best interest test and all the debates around valuation. Wouldn't allowing creditors to propose an alternative plan, basically putting their money where their mouth is regarding valuation, for example, be able to solve both of these aspects?
Okay, so the experience in the United States with terminating the exclusive period where the debtor is the monopoly proposer of the plan is that creditors just will propose any number of plans, and it will confound the debtor and confound the parties because you have to consider these different options. There's just no way to reach consensus, and in almost every case where the exclusive period has been terminated, the debtor ends up in liquidation. It's almost impossible as a practical matter to reach consensus.
So if I could just add something very quickly to that, I think it is, judges, I think, are increasingly willing to say, to the extent that a creditor is objecting that some valuation that's proposed is too low, while go out and raise the money and put a better offer on the table. And then if you can do that, I'll terminate exclusivity, or I'll encourage, or we'll look at doing a 363 sale. I think that kind of using the market to test a valuation is something that has become increasingly common in Chapter 11 practice in the last kind of 15, 20 years or so. And Mark Rowe, who's an academic at Harvard, is just like publishing a kind of history that talks about this, if you're interested.
Okay, so I think we have to stop. I just want to thank you all, because I think it was extremely interesting this evening, and to be frank, I learned a lot by preparing this conference with you, and I hope we will have long debate again in order to make sure that the new reform that we will do of our insolvency law will take into account the lesson from 15 years of Chapter 11. Thank you.
Thank you all.